Right. This presentation covers adverse possession, encroachments, and prescription in Georgia. So, adverse possession and prescription are common legal principles that surveyors should be aware of in all states. Like so many laws and legal philosophies, though, these topics will vary from state to state. And one nuance that you may notice early on is that in Georgia, the legal principle of adverse possession in the code section is addressed with the official term as being prescription. Now, in practice and everyday conversation with other surveyors, attorneys, so forth, adverse possession is the usual term, which basically means fee simple title is what's being sought or has been acquired, and prescription actually refers to prescriptive easements. You may hear people say, well, that easement is there by prescription, or they could claim that land behind their house by adverse possession. So they're pretty similar, prescriptive easements and adverse possession, but there are some differences that are unique in Georgia. And Georgia is also a little different from from other states, just like there are these nuances. In that several other states, particularly Tennessee, if you can demonstrate that you've been paying property taxes on contested land, that can weigh heavily in a court decision. So when prescription or adverse possession is used, it's basically taking a right or property from one owner and giving it to the other due to their possession. So you may hear this referred to as squatters' rights, which are generally different in the Western frontier, but there are some actual society values in this that go back even to English common law, like many of our property laws do. So the most basic function is to protect people who act in good faith and spend their money. And if nobody stops them, then it just seems unfair in the gist of English common law to eject them from land that they have been um, adversely possessing. So there's another reason that if throughout the early days, years of our country and state, there was an impetus or a very pro-growth type attitude. They wanted the land to become developed and used. And so they didn't want anything out there that could discourage somebody from going and developing. So that's how some of the squatters' rights laws got really focused in the western frontier in the 19th century. Was people would go out and thought that they were doing good. They'd build homes, they'd have families, they'd have some cows, they'd have a garden or some crops, and then the rightful owner, maybe the railroad company, maybe some investor from another state would come in and have them removed, uprooted, just totally destroy their lives. And so the the government, the legislature, the executive passed laws to protect people from that. There are actual squatters' rights laws in Georgia that generally are dealing more with, it's along the line of landlord tenant law. It addresses when people come in, usually vagrants, and start staying somewhere on property, in an apartment or an abandoned house. They can't even be house guests for that matter, but that's generally not anything that's going to be to the attention of a land surveyor. But it does get mentioned that if the squatter is allowed to stay on the property and possess it for 20 years, that even without color of title, they might obtain adverse title. Now, about that, in Georgia, the legal elements for adverse possession to ripen into actual title is 7 years of possession with color of title or 20 years without color of title, and we'll come back to that. The possession cannot be permissive. In other words, it must be adverse to the actual title owner. People must be acting in good faith that they think it's theirs or that they have a legal right to occupy the land, and therefore they don't need anybody else's permission. Kind of ties into the next point that it can't be an act of fraud. So they can't knowingly go on the lands of someone else and hope to acquire title by adverse possession. The possession must be open and notorious, continuous, and exclusive, aka hostile. Now, hostile doesn't necessarily mean that we have armed hostilities, but that the occupation would be protected as if it were one's own land. Now, color of title um, is a legal concept or term that means a writing, a document, or other instrument, some piece of paper that appears to convey the title to someone, but in the case of adverse possession, it may be or it is defective. Now, one court ruling said that having good title is not color of title, it is good title. Color of title is basically flawed title. So, if the possessor of the land had good title, it would not be adverse, it would be theirs. So, the term applies when someone is occupying the land of another because they don't have good title. Therefore, it's not theirs, it is the other. Um, so the defects can be either basically in two ways, either in the description of the property or in the underlying title. For example, if you have a bad description and it calls to be northwest from a certain point instead of northeast, which it should have said, and a person assumes that the deed is correct and goes in the northwest direction and occupies land that they believe is theirs based on that, that would be an example of a flawed description. Or if it says, if the description somehow could be interpreted to be more than one place and an unknowing property owner picks the wrong place and occupies land that is outside of their actual title boundary, then that could be a defect in a description. And the description is normally going to be in a deed that purports to convey title to the possessor. But the flaw can also be a flaw in the underlying title. For example, if uh, there were three heirs and only one heir signed the deed and said, "I'm signing on behalf of the estate of John Quincy Adams," and someone pays that heir money, goes out and starts occupying, building a house, farming, whatever, and then the other two heirs come up and say, "Wait a minute, that's 2/3 ours. You got to get off." Then the title is flawed. There are other flaws in the underlying title that they can creep up, such as there's a typographical error in the description and it describes someone else's property, or an owner sells land to someone who moves on to it and begins to possess it, but there was actually a lien against it, a bank loan, for example, and the bank comes along and forecloses and evicts the new buyer because the foreclosure and the security deed preempt and are more, they're lawful, whereas the buyer or the previous owner's conveyance was not. So these are title matters, not survey matters, but these are things that we have to deal with and try to interpret title descriptions and so forth. You know, some of the other requirements uh, is that the physical attributes of the possession be open, notorious, and hostile, or uh, uninterrupted. There are some other terms that will be used. Though that term is somewhat antiquated, it still describes the elements that the laws look for. So the occupation must be visible and of a nature that an owner would exhibit over their own land. Thus, it is exclusive, and this alludes to the fundamental private property right to exclude, or to exclude others from coming onto your property. When you own property, you get to decide who comes and who doesn't. And hostile just alludes to the principle of defending your ground, standing your ground, even if hostilities are required. So, these all speak to the requirement of the belief of the possessor that it is theirs. Structures, mowing, like lawn maintenance, cultivating crops, or work yards, where they might work on equipment or unload materials and things for their job, or operate a sawmill and a lumber yard. These can all be active and open acts of possession. The law, however, looks more dimly on things that are less intensive, less open, less hostile, such as occasionally cutting timber on someone else's land, going onto someone else's land for hunting, or mere trespassing onto another's land. That these things do not meet the threshold for adverse possession. Another concept that's necessary is that it's not permissive. In other words, if the rightful owner gives the possessor permission to enter onto their property for whatever purpose, then it's not hostile. It's not, the possessor is not occupying the land as if they believe it is theirs. They, in fact, know that it is someone else's. And so that becomes a different, like a landlord, tenant, renter type situation, not where adverse possession would ripen. Permissive use is generally termed as a license. Now, these can be written and documented. Sometimes some owners will require that they don't mind the neighboring property owner using, part of their property for a certain purpose, but they want it documented so that it cannot ripen into adverse possession. Most licenses are mere verbal agreements between neighbors, and the law refers to these as parole licenses, just like parole evidence. Another form of a permissive use that would not ripen into adverse possession is a lease, where for money, for consideration, the occupier is paying the actual owner and therefore recognizing that it is the owner's property and not theirs. The law also, in regards to renting, kind of changing gears, is that if you own property, it does not have to be you yourself, the name on the deed that occupies it. It could be your family, it could be renters, it could be employees. Uh, it doesn't have to be residential; it can be commercial properties. In other words, employees. So there's another aspect that will come into play with surveyors in that the time period needed to accrue title can be satisfied by successive owners. So, in other words, if three different owners own the property for 3 years apiece, the first owner, starting on day one, starts adversely possessing somebody else's property. Maybe they own property and they don't know where the boundary stops, or they think that under color of title their boundary extends further to the east. And so here's this, maybe there's a house built. Well, that first owner owns it for 3 years and sells it to owner number two. 7 years hasn't passed. Owner number two owns it for 3 more years. And at the end of that, they sell to owner number three. Well, only 6 years have passed. At this point, owner number three shows up within the first 11 and a half months or 364 and a half days or whatever. The actual owner could come up and say, wait a minute, uh, your house is on my property. And then the clock stops. They're on notice. It's a legal function as to whether they have to file a lawsuit within 7 years or if they just have to state objections. But that's a legal matter. But just say that the owner number three, you know, stays there for 2 more years before it ever comes up, then you've got 8 years. That satisfies the 7 years. But then for this to go forward legally, then you have to go back and get proof of the first two owners' occupation. And this process is known as tacking. You tack one ownership onto another. Has to be continuous though. So if owner number three did not occupy the land, did not occupy the house, just bought it, it's arguable in a legal function, which is outside of surveying, as to that if that stopped the continuality of the possession or not. So, kind of summarizing on this, land surveyors don't have to be fluent in these legalities. We are not attorneys. We just have to be familiar with the legal principles and the relevant aspects of law regarding what we do. We may be called on to opine as to whether any type of encroachment or adverse occupation, how old it is. And that may go to interpreting aerial photographs, prior surveys that showed a structure or a fence or some occupation at a prior point in time. If it was five, if say the survey is 5 years old and it shows the encroachment, well, we have evidence and reason to believe under our good faith practice that the whatever that was there 5 years ago. It could have been there 10 years ago. We just don't know. We just have to speak only to the facts. Uh, so land surveyors don't have to be fluent in all these legalities. Just be aware of what's going on around it. In other words, you can work on a car without being, qualified to overhaul an engine, but you need to know when you're working around the engine what it's doing, or the car won't start. So specifically in application to Georgia rules and laws, well, there are three specific board rules that drive this home. 180-7-0.07 D16 requires surveyors to show the character of any and all evidence of possession along or related to boundary lines. That's pretty conclusive. If there's anything along the boundary lines that indicates possession, we need to show it. And we don't have to write an essay about it, but if it's a fence, if it's a clearing line, if it's a row of marked trees, anything that speaks to it, we're required to show that on the survey. Now, part of it may be to put the world on notice of some adverse possession. Another function is to let the totally outside of adverse possession is that the client or the public or a subsequent owner can look at it and say, oh, that fence is not on the line. I see some space between the fence and the boundary line on this plat. Or that row of trees, surveyor says that they're all along the line, so we can count on that to know where to stop cutting timber or clearing land or whatever. Board Rule 180-7-0.07 D6 requires us to show apparent encroachments. So that really is restating evidence of possession. But if we believe it's an encroachment or an apparent encroachment or a possible encroachment, it all falls under the realm of any and all evidence of possession along the boundary lines. And tying into prescriptive easements, which we'll cover shortly, the surveyor is required to show the widths and former widths, if pertinent, of easements or right-of-ways adjacent to or crossing the property line. Notice that this requirement is not limited to recorded easements or right-of-ways, and thus it requires us to do the depiction and reporting of possible prescriptive elements such as roads or trails crossing the property line, or any utility features or evidence. If there's a power line that crosses the property line, well, that's a clear indication of an electrical easement, whether if it's recorded and in the record or not. And to be fairly conclusive here, the ALTA NSPS standards speak to this in section 5.C.3. And I've added the emphasis here, but without expressing a legal opinion as to the ownership or nature of the potential encroachment. I really like that verbiage. So we'll come back to that in a minute, but it says the evidence, location, and extent of potentially encroaching structural appurtenances and projections observed in the process of conducting the field work. Thus, surveyors must be able to identify and locate all of these features and adequately depict and report them. Adverse possession basically starts as an encroachment. You could even take the position that for the first 6 years and 364 days that it's an encroachment, and after that it becomes adverse possession. But adverse possession really starts on day one, but adverse possession starts as an encroachment. So surveyors are charged with locating apparent encroachments and evidence along the boundary line. So what are encroachments? So here's 4 bullet points. An encroachment is an unauthorized intrusion into a neighboring property through the creation or extension of a physical structure, including flora, plant life, landscaping, bushes, grass, above or below the surface of the land. 2, to enter by gradual steps or by stealth into the possessions or rights of another. That first bullet point is from the Cornell Law Institute page. The second is from the Merriam-Webster Dictionary. Third, from law.com, to build a structure which is in whole or in part across the property line of another's real property. That's definitely the structural side of it, but the ground around it can also be an encroachment if it's adversely possessed. And in Georgia, I'll bring up OCGA 16721A that says a person commits the offense of criminal trespass when he or she intentionally damages the property of another without consent of that person. Now, it doesn't really say whether if they realize that it was the property of another or not, but an encroachment is a term of a trespass. And again, we're not attorneys, but know that there is a difference between a civil trespass and a criminal trespass. Obviously, someone breaking into a house or jumping onto somebody's property and doing damage, that's criminal trespass. That's generally not what an encroachment is going to be. Um, Physical occupation, mowing limits, gardens, we've covered all this. So this last paragraph here on encroachments is something worth dwelling on, and that surveyors must be careful to neither underreport nor overreport encroachments or areas of conflicting occupation. Uh, Many attorneys and title agents will demand that surveyors report all encroachments, show that encroachment, and describe the encroachment. But in order to truly call out something as an encroachment, that's basically a legal opinion. Otherwise, how are we to know that it's not permissive use? How do we know that this is part of adverse possession? It may be permissive possession, and we just don't know. So I give a couple of examples here. Just say that there's a 10-foot wide shed and it's over the property line. Well, we're not to say, unless we have bona fide evidence that we're willing to stand behind and be cross-examined in court over our statement, we don't need to say that's the neighbor's shed or that's our shed or it encroaches, but we just state the facts. So rather than saying, let's say it's 4.5 feet um, onto our property, 5.5 feet on the neighbor's property, rather than say that it encroaches 4.5 feet, which may be wrong, we can actually affirmatively and factually state that the corner of the shed is 4.5 feet west of the property line. And that satisfies all of our requirements, even under ALTA specs. There are people who will push us to say, call that an encroachment. You need to tell us that's an encroachment. And sometimes that has some contractual background. In other words, uh, there is perhaps due diligence in the contract that the seller must identify, report, and resolve any encroachments. And so they need us to say what those encroachments are. But again, we don't know whose shed it is, who put it there, if it was with permission. Let's say that it is the neighbor's shed. Let's say that it is 4.5 feet over the line. Before you call it an encroachment, realize that if Bill came over to Ted, our client, and said, hey, do you mind if I put part of this shed over the line? I don't have enough room over on the side of my driveway. And Ted said, yeah, sure, go ahead and put it there. I don't care. That's not any that's not really an encroachment. That's not adverse. That's a permissive use. So it's not a trespass. It's a permission. I'm allowing you to come onto my property and place that shed. But it's also, and I saw this work the other way. What if it's our shed? And it's 5.5 feet over on the other property. We just don't know these things. So be careful what we report, but don't under-report. If there's, a mow line where somebody's mowing the grass and maintaining 8 feet of our property, that's definitely is a requirement in Georgia and most states to show that. Even if there's no structure over the line, that is occupation by another. That's potential adverse possession that we need to show. And instead of maybe using the terms adverse possession or any of these things, just say mow line of adjacent property extends into subject property 8 feet. Now maybe the neighbor came over and asked our client or previous owner permission to mow that part of the lawn because Maybe there was a yellow jacket's nest that they wanted to take care of. There's all kinds of reasons that can explain permissive uses or parole or even written licenses. Just stick to the facts and report them accordingly. Don't make assumptions. Consider this. I know of a situation very similar to this, which I'm doing a hypothetical on. Surveyor says that fence encroaches by 10 feet. It derails the sales contract because the seller is supposed to have clear title, and they don't have clear title to that 10 feet of the fence. What actually had happened is the little girl next door was raising a goat for FFA, didn't have enough room, came and asked the property owner, can I put my fence, or her dad said, can I put part of my fence over here for the goat pen on your property? And of course the owner said, yeah, sure, that's fine. Best of luck to you. And there is the fence. Well, then he goes to sell. I think in this case, the actual owner who had given the permission passed. His estate and his heirs are now selling the property. They don't know that much about it. They didn't know that dad had gave the neighbor permission. They don't know anything about this, but the survey shows it up. Here's a fence encroachment, 10 feet, causes a big blow up. Well, all they had to do was go to the neighboring property and say, what's the history behind this fence? Oh, well, your dad let us put part of the goat pen over there. Do we need to move it? Yes, please do. Okay, now it's gone. Problem solved. But the surveyor called it an encroachment when it really wasn't. It was just a fence that was 10 feet over the line. That's factual. But to call it an encroachment implied a trespass, implied something that was against the owner's will, which was not true. The surveyor was subsequently sued for damages for causing this sale to fall through because he called it an encroachment when it was actually more permissive use. And they settled for something far less than the purchase price of the property, something like probably $25,000 if I remember correctly, and close to that much in legal fees, and a whole lot of time spent talking to attorneys and in court and not making money. So let that be a reason to be careful not to overstate or call something that you cannot back up with a surety. Similar to adverse possession is our next topic, prescriptive easements and right-of-ways. So similar to how adverse possession can ripen into fee title over a period of time, easements can also ripen undocumented over the lands of others. The statutory basis is in OCGA 4491, which says that a right of private way can be formed from prescription by 7 years, uninterrupted use through improved lands, or by 20 years use through wild lands. Now, the law doesn't define what improved or wild lands mean, and they can even vary from one part of the state to the other. I was told that in one judicial circuit, close to Atlanta, that the court had said that if it's within city limits, it's improved. If it's not in the city limits, it's in the rural area and it's wild. Don't know that I agree with that, but at least there is some logic there. And this was many years ago when the unimproved parts of some of these metro counties were, forest or farmland. There are court cases where they say that improved lands may be lands with home sites, cultivation, or any kind of intentional use, farming, grazing, etc., or commercial activities. All this can be used as improved lands. But again, this is a legal argument that the surveyor doesn't really need to be able to rule on or state uh, unless you see an old road that was shown on a 23-year-old plat. It might be worthwhile in the best interest of everybody's interest to say, 12-foot gravel road, easement rights unknown, shown on plat book, blah, 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 or also shown on plat by Jones in 1997, whatever. Because this is a legal argument, not a surveyor's determination as to whether if it's been there 7 years, 20 years, if it's wild lands, improved lands. Just know that these are the framework of the law that surrounds what we do. So we need to know this is basically, in a legal sense, our work environment. So there is a little contradiction in how prescriptive rights are applied as compared to adverse possession is that a permissive use, again, a parole license from one owner to another to cross the other's land, can be revoked, just like a revocable license or parole license to put the fence for the goat pen on the other land, etc. But it can be revoked only if the revocation, and this is in the law, 4494, only if the revocation does no harm to the person using it. Now that's pretty subjective, would have a pretty low bar. Well, it's an inconvenience for me to drive around. I want to keep coming through your property. So you've harmed me by telling me that I can't. Now I have to drive further. Doesn't say how big the harm has to be. Now there's going to be some limits of common sense probably. But it specifically says if the licensee has incurred expenses, in other words, they put some gravel down, they had somebody scrape the road, had someone pave the road, if it's a paved driveway, if they treat it, seal it, repave it, pay to have trees cut out from around it or something, if they have spent money on it, the law says that it becomes an easement. In other words, even if it's permissive that you let someone cross your property, if they've not spent any money on it and you want them to stop, you can say, okay, quit now. I don't want you coming across my property anymore. You play your radio too loud, etc. But if they've spent money to use that way, that path across your property, they can contest that. And if the law is applied and there's nothing to hinder it, then the court will grant them an easement without your signature. So any roadway, this is something to emphasize. Any roadway or path that's crossing a property line, it can be potentially an easement, even if it's not documented in the public records. All it may take is a week of using that driveway and paying money to have gravel dropped on it, and they can contest that they're revoking of the right to use that and have the courts enforce it into an easement. And the surveyor's liability is if the surveyor does not show this and accurately depict these roads and paths and ways on their property, we're not putting the owner on notice of their existence. And if they are damaged by them when we failed to follow our rules and put them on notice, then the damages will be paid by the surveyors. So outside of that, the prescriptive easement, outside of parole license implications, it can ripen into legal status in 7 years or 20 years if it's wild land, but it can also be extinguished the same way. So say that John crosses Bill's property for 9 years in an improved area, so the 7 years has been met. The law would give John an easement if he had to sue Bill and take it to court. But whether if he does or not, really, if that prescriptive easement then is not used, John quits using it, Bill closes it, Bill begins prescribing or adversely possessing back against that prescriptive right, generally understood to be at the same rate, 7 years. The law just says a term sufficient to raise the presumption of release or abandonment. So a lawyer might could argue that you don't need the full 7 years. If John's now coming in a different way and he's not even used that, there's logs piled in the road and it's not even passable anymore, well, they might could, if it's only been a year or two, argue that that is a presumption of a release or abandonment. So the prescriptive easement may be lost. Something else that's important for the surveyor to understand is that prescriptive rights are limited to the use which has constituted them. So once they're established in court and are valid, then recorded easements, the use can't be expanded just because the user wants to. So hypothetically, let's just say that Brown and Red Clay Timber Company crosses the Joneses property to get to their landlocked timber tract for a sufficient number of years, whether if it's 20 plus in wildlands or whatever. And so their activity over the Joneses property is to go check the timber, make sure they don't have beetle infestation, or they don't have a pine blight or some other kind of fungus. They're just managing the timber. They want to make sure that there's no deadfall piled up and anything composting that might heat up or be particularly susceptible to fire in a dry time of the year. And of course, if it's timber, every few years they're going to come in and cut some of it down and haul it off in big trucks. They're going to come in with big timber equipment, skidders and bulldozers, and get the timber loaded up on the trucks and hauled out. Now, if the Joneses decided they didn't want BRC coming off anymore, wanted to cut them off, they would probably lose if enough time had passed, and the court would grant BRC an easement. But and this has been tried. BRC can't take that prescriptive easement and try to use it for another use or to expand it. All they can do is continue to come and manage that timber and harvest it every few years. They can't come in and develop subdivision. They really can't use that prescriptive easement to even build one single house, much less a subdivision, because residential traffic, construction traffic, delivery of building materials, that's not been exhibited continuously for 7 years. There's no legal threshold met to allow that activity to even start to happen. So Jones could say, no, no, no. Your timber people, your employees of your company or your agents, they can keep coming and going. But these builders and these building material delivery, they can't. It also does not expand into utilities. Utilities have not been there. They've not been part of BRC's possession, occupation of the land or their use over the Joneses property. So BRC or their subsequent seller or buyers of the property don't have any right to come in and start using this prescriptive easement for utilities. There's another legal concept of easements that the surveyor needs to be aware of. You may even be called in to be a consultant or to aid in a easement by necessity. What this basically means is if a piece of property is landlocked, has no legal access, and let's say that there is no road or path into the property that could constitute prescription, because the law would basically require that a prescriptive claim be pursued in such instance, not an easement by necessity. So the easement by necessity code is 44940. And this basically just says that if you're landlocked, you can file a suit under 44940 claiming an easement across an adjacent property. Now, it's generally understood that the claimant, the plaintiff, the person who files the lawsuit, they have a burden of proof of deciding whose property is best served to provide that access. If it's a small piece of property and you'd be coming right by somebody's living room with a road, that's not well served. If it's vacant land that's gentle terrain or a driveway or road has minimal or at least lesser impact, then that's the way the court would typically rule. There's also the aspect of if the property came out of another parent tract, then an adjacent property survives or remains in, that's a good place to start, because when the landlocked property was cut out, if it was landlocked to begin with, well, there's probably an implication of access through the seller's remaining lands. But these are things that come up in an easement by necessity. Some things to point out is that the law says that an easement by necessity cannot exceed 20 feet in width. So it's never going to be wide enough for a two-lane road with shoulders on each side. It's not, sometimes in challenging terrain or topographical features, it's not going to be wide enough for cut slopes, fill slopes, drainage structures, or erosion control measures. I ran into a situation where it was arguable if they could squeeze the slopes necessary to build a single lane driveway within the 20 feet that the court had granted. It was really tight, but the county required them to put silt fence in, but below the fill slopes, and to put riprap at the end of the culverts. Well, the culverts had to be turned at an angle so that they didn't stick out of the 20 feet of width, and there's hardly room for the riprap to stay within the 20 feet. So the other side, who was very angry about losing the easement by necessity, and now this person they didn't know or like has a right to come through their property, they were kicking and screaming every bit of the way, determined that the silt fence was outside of the the court ordered 20-foot easement by necessity, ordered it removed. It's a trespass. Now you're damaging my property. And so it's just a lot to know that things can evolve in that. And so basically, this is a form of condemnation against the property of the adjacent property owner. They're having this easement condemned, but it's not being condemned like a land for a new road or for widening an existing road. This is for private purposes because the government's not going to maintain the private way that the easement by necessity creates. So land that is adjacent to landlocked property is always at some sort of inherent risk of an easement by necessity suit. So that's really not a survey matter that we have to alert people to, but it's something to be aware of. I have even pointed it out on occasion where I felt like it was necessary when I realized that the adjacent property was landlocked, that it backed up to rivers or government property, and the only way that the adjacent property was ever going to get access was through my client's property. I did make a note on the plat that, now formally BRC timber note has no legal access. Now, I didn't drive that home. I didn't try to derail any closings. I'm just putting the user of my plat, particularly my client, on notice that the property behind you is landlocked. So, just be aware they might come back with an easement by necessity someday. So we're going to summarize and move on from this topic. So, contrary to what some realtors or clients may want to think or may want to convince us of, adverse possession and prescriptive rights are unwritten, undocumented, and they can always be challenged in court by the true owner. Some will argue. I've had realtors say, I learned in real estate school that if you use it for 7 years, it's yours. Yeah, that's true, but it's not that simple. It doesn't just happen overnight. Um, there's no adverse possession ranger that the county hires to ride around and take notes. Oh, he's documented. He is on her property. Notice this first date, July the 18th, 2024. Okay. Now we're going to come back and keep checking on that. And when 7 years has passed, we're going to write them a ticket and say, that's no longer your property, buddy. She has been adversely possessing it, and now it's hers. No, it doesn't happen that way. It's, some will just argue and say, I've been clearing that's mine now. You need to get your stakes out of my yard. That's where your title boundary is until a court upholds adverse possession as being valid in this case, and they enter an order that grants part of their property to be your property. Until that happens, that's their property, even if you're maintaining it. If you want to earn title to that, you have to take them to court. Now, understand that most of these little common or these little minor aspects and situations of adverse possession and encroachments, the legal cost is never going to be worth what the property is. It's cheaper to move the building. It's cheaper to just quit mowing over there, build a fence, and stay off their property. It's seldom going to be worth the thousands and thousands of dollars to get that. Sometimes in commercial property or where building setbacks or minimum sizes are impacted. Just imagine that there's not an ordinance in the county that protects someone from judicial decree in their minimum lot sizes. And they have to have 0.50 acres to get a building permit, and now they do, but they lose 0.04 of an acre in court due to adverse possession by the neighbor. Now they have 0.46. So they might have a really good reason to fight there if they're not protected otherwise, because otherwise they may not be able to build on their lot. And now it goes from a building lot that's worth $70,000 to just a half acre of land in a subdivision that's not worth anything because they can't do anything with it. So going back to that, the laws regarding adverse possession are theirs for the court to use in their rulings. They're not there for the surveyor to apply. This is not the quasi-judicial function of the surveyor that Justice Cooley was referring to. We are there as fact finders and to report the facts and just the facts. The adverse party, the adversely possessing party, bears the burden of proof and the requirement to file a lawsuit or to defend one. And, sometimes they'll say, well, that's mine, I'm going to fight for it, and they file a lawsuit by adverse possession. and it gets into the court system, and then the true owner defends it. Sometimes it's the reverse. The true owner uh, wants to get rid of the adverse possession, even though the adverse possessor's not taking any legal steps to earn title. They realize that their title is clouded by the adverse possession. So, in certain situations, they may need, say in the half-acre lot example, they may need to file suit in order to protect their rights. The true owner or the other party has the constitutional right to due process. They get their day in court. They get to make their opinion. They get to defend against the claims of the other side, and uh, whoever wins, that's entered into the court records. Most attorneys are smart enough to put that also in the deed records, but that's not really a requirement of the civil court when it comes to rulings. So sometimes people will tell you that was decided in court. I was there when the judge rapped the gavel. Well, I've been to the deed records and I've searched every which way under your name, their previous owners, and I can't find it. Well, you're really not through. You need to go to the Superior Court docket, or in some cases, according to the time frame, the probate court docket, and search by those same names in the court dockets. Sometimes you will find the lawsuit filed, and it's just as valid. It just never got recorded in the deed records like it should have. So again, we're not attorneys, but we're required to be knowledgeable and proficient in the relevant areas of law and to be able to do a good job for our clients and know what happens outside of the four corners of our plat that can affect people and affect them financially. And that's why we have these rules and why we have to follow. Thank you.